in about a minute here. I just wanted to make sure that everything is working properly. So if you're on here and you can hear me, I appreciate if you just do a little message over in the chat bar and let me know that you can hear me. Once we get that figured out, okay, looks like people can hear me. Great, wonderful. All right, so a little bit of housekeeping. There is a slideshow, and there should also be video of me. There should be in different spots on your screen. If you can't see me or if you can't see the slideshow, maybe you can scroll over to the right or left, or maybe up or down to see either the slideshow or me, or maybe you can see both. Thank you, everybody, for your feedback. All right, so once again, my name is Dan Kraus. I am an attorney in Wisconsin. I practice estate planning and elder law and probate and trust administration. We focus on these areas of the law in our firm. We don't do divorces. We don't do bankruptcies. We don't do criminal defense. We don't do mesothelioma or whatever that is. We do estate planning. We do estate administration, and we do elder planning, and really that's it. So we do it well, and we hope to do it and help as many people as we can. So today's presentation is focused on estate planning. Now, all of the concepts that we're going to be talking about today are Wisconsin specific. Now, most of them will apply to almost every state. However, I don't practice in every state. In fact, I'm practiced mainly in Wisconsin. Although I am licensed in Illinois and Minnesota, I really don't do much practice there. So anything that's specific about these slides or anything that I say, you can apply it to Wisconsin or Wisconsin law. But if you are in another state or you're concerned about another state, take it with a grain of salt because it may not apply. So that is my first spiel. As Laura said in the chat, please, if you have a question anytime along this, just type it in the chat and we'll get to it at the end of the presentation. Presentation should be about 20-30 minutes, and then we'll have time for question and answer at the end. All right, let's see if I can, okay. All right, a little bit more about me, my background. I was born and raised in Wisconsin. I went off to the Army at 19 years of age. I got out, I got back in. I eventually retired from the Army as a JAG officer in the rank of major. Very proud of my military service. I also served in the Peace Corps during the middle of one of those off times from the Army. A couple of years I served in Kenya. That was also very interesting. As far as estate planning and my expertise in this area, I've been doing this for 25 years. I am one of 7 certified estate planning law specialists in Wisconsin. There are many more throughout the United States, but in Wisconsin, we've only got 7 specialists. Also, one of the few firms and people who will do Medicaid planning in Wisconsin. Also, I wrote a book called Estate Planning in Wisconsin, and I'll show you a picture of the cover of that book in just a second. But these are some of our accolades and our memberships. We focus our practice, like I said, in narrow areas, so we belong to groups that focus also in those narrow areas, like the National Association of Estate Planners, Wealth Council and Elder Council, the National Academy of Elder Law Attorneys, etc. So what is estate planning? Estate planning is essentially arranging your affairs in a legal way that can take advantage of the laws so that you can decide what's going to happen to your stuff if you become incapacitated or if you die. Not only your stuff, but your person. You can plan to what's going to happen to your physical person if you become incapacitated and somebody needs to make healthcare decisions for you, or if you become incapacitated and somebody needs to make financial decisions for you. Essentially, it's putting your ducks in a row so that if something happens, you are covered. So the very basic minimum of a comprehensive estate plan, and these are documents that everyone should have, at least a will, a financial power of attorney, and a healthcare power of attorney. Those three things are the basis, the three-legged stool of estate planning. Now, the estate plans that we do are typically more than a dozen documents, but for people who want the bare minimum, or people that have the bare minimum, this is it. If you don't have one of these, your estate plan is not what we would consider to be close to comprehensive. So let's talk about powers of attorney. So if you are incapacitated or you can't make decisions for yourself, you need to have powers of attorney in order to help you to make those decisions. You can appoint someone to be your agent under this power of attorney to make healthcare decisions or medical decisions. So let's talk about what happens if you don't have these documents. Well, if you don't have these healthcare or medical powers of attorney in whichever area, then the state law is going to control. So what does the state law say? If you are incapable of making decisions about your health care, if you are incapable of making decisions about your finances, and you have not got a power of attorney, then you have to get a guardianship, or your family or somebody has to get a guardianship over you so that these decisions can be made. Now, the process of appointing a guardian has to go through a court. There has to be a hearing, has to be in front of a judge, and the judge has to decide whether you are actually incapacitated. And then the judge makes other decisions about how many powers are they going to take away from you and give to the guardian. Now, most times the judges just check all the boxes and say, take all the powers away from this person and give them to the guardian. So now, things like your right to vote can be taken away. Now, they can't be given to your guardian. Your guardian can't vote for you. But things like making medical decisions, deciding where you are going to stay, whether you stay married or get divorced, these are all things that a guardian can decide for you. Kind of scary. Also, the guardian then would become in control of all of your finances. So the guardian would decide where your money gets spent, where it gets invested or not invested, etc. So some unintended consequences for people that become incapacitated because, and they did not create powers of attorney in advance, is that you can end up with a guardian that you wouldn't want, somebody that you don't get along with in your family, or maybe somebody that you've never met or even heard of before could end up being your guardian. And then, of course, you've got the expenses and the embarrassment of court. So what's embarrassing about the court? Well, in order to protect your rights, the court says, the law says that you have to be brought into the court. Even if you're not aware of your surroundings, they have to bring you into court to give you an option to object and make your arguments just in case you want to make arguments, or so that the judge can be sure that you're not being hoodwinked or imprisoned and somebody is just coming in to get a guardianship so that they can steal your money. They need to bring you into court, and then there has to be the doctors generally and others will testify about your inability to do certain things. And who would want that? That's embarrassing. You'd want to avoid that. So instead of going with the guardianship, which is the state's plan, you should have your own plan. Create tools, power of attorney for finance. Generally, you want a general power of attorney. That means one where your agent can do almost anything that you can do, so that if you become incapacitated, there's no limitations on what they can do, so that if they come across a limitation in the power of attorney, now they're going to have to get the guardianship anyway. So powers of attorney, generally for estate planning purposes, are very broad and general so that they encompass everything that a person could do. They give the power to somebody else without having to do the guardianship. So there's also the healthcare power of attorney. That's a standard state form. Some people use non-standard forms. We always like to use the standard state form, tweaked just a little, but enough so that the doctors, nurses, and facilities all recognize the form. Because anytime a doctor or nurse looks at a form and they don't recognize it, they get nervous. So we like to use the state form so that the medical professionals know what is there. A lot of people like to do living wills. A living will is nothing more than a document that says, if I am in a persistent vegetative state, or if I have an illness and it's my death is expected to be imminent, then I don't want procedures or medicines used to prolong my life, and I don't want feeding tubes used. These things can be said in these documents, and then you don't have the Terri Schiavo problem. So for people, if anybody remembers Terri Schiavo, put something in the chat. Terri Schiavo case was a really sad case that went on at the end of the last century, 1990s and into the 2000s, just the very early 2000s. This woman was on life support for 15 years before they allowed them to pull the plug. And once they did, she was gone within 2 weeks. Not anybody's idea of a great life. Certainly not a life that her husband wanted, or even her parents. And imagine the cost of keeping somebody on life support in a hospital for 15 years. Also, trusts. Trusts are another way that you can plan to control your assets during an incapacity situation. So if you create a trust, you put your assets or some of your assets into the trust, now you become incapacitated, and your successor trustee then is able to manage those assets, and you don't have to worry about guardianship. Now let's talk about wills, the third leg of the three-legged stool. So we talked about the healthcare power of attorney. We talked about the financial power of attorney. Now wills. Wills only affect things after death. Your will is only an after-death document. It's a document that has very strict and specific rules as to when it's valid. It has to be properly signed, properly notarized. You can't do it when you're incapacitated. You can't do it when you're under duress. You can't give money to certain people if they're going to be a witness either. So you have to be careful of who is the witness, etc. So let's back up a little. If you don't have a will, the state law controls, just like under the powers of attorney. In this case, it's not a guardianship because you're already dead. So what happens is called intestate succession. Intestate succession or intestate probate proceedings just means that intestate means no testament or no last will and testament. So a person has not planned. So state law, intestate succession, in every state, it's essentially the closest relatives get your stuff, but each state interprets that a bit differently. Illinois is different than Wisconsin, which is different than Minnesota, but they're different in subtle ways. I'm most familiar with Wisconsin rules of intestate succession, so I can tell you how that would go. For a person who is married and has no children, if they die without a will, everything goes to the spouse. If a person is married and has children, and all of those children belong to that married couple, still the spouse gets everything. If a person is married and has children that don't belong to their spouse, now things get complicated because all of the children get half and the spouse gets the other half. It's fairly complicated determining what's marital property and what's individual property, but in general, the children get half, and then the spouse gets half when the children don't belong to both spouses. Now, if a person dies without spouse and without children, everything goes to the parents. Or if only one parent survives, it goes all to that parent. Now, if both parents are dead, it goes down the line from the parents to your siblings, so the parents' children. And then if any of those are deceased, then it goes to their children, like nieces and nephews, etc. So that's how Wisconsin intestate succession goes. There's further, if there's no nieces and nephews and all of that, you actually go to the grandparents and then the aunts, uncles, then cousins once removed, etc. But in a second marriage situation, it's really important to do estate planning, to write it out and do a will, because you don't want the state law to control. A lot of times when people don't have a will, their surviving spouse gets left out in the cold, or the children get left out in the cold, or there's a big fight and the surviving spouse tries to run away with everything that's supposed to be partly the children's inheritance. Just a mess. You don't want that, so at least do a will. So intestacy, like I said, intestate, this happened to James Dean. If you're familiar with James Dean, he was a moody, young movie star that did movies like Rebel Without a Cause. Very popular, but he died when he was 24 years old. He was driving a fancy sports car and somebody turned in front of him and boom, smash, he was gone. And unfortunately, like most 24-year-olds, he didn't have a will. For most 24-year-olds who aren't married and don't have any kids, they want their parents to get everything anyway, most times. However, James Dean had a specific situation where his mother died when he was young. I think he was about 8 years old. His mother died. I don't know what she died of, but it was sad. The father then essentially just pawned him off on the mother's sister. So James Dean was raised by his aunt. He did not get along with his father at all, but when he died, everything, including all of his royalty rights, millions of dollars, went to his father. Not something that he probably would have wanted if he could have gone back and done a little bit of planning before that fateful car ride. So there are still pitfalls of doing wills, which can be remedied if you do a trust. Now, with a will, just like intestate, if you don't have a will, all of your assets are then going to be administered through the probate courts, which means there's a court case after you die. Most people would like to avoid a court case. So the court cases can be lengthy, it costs money, it costs a lot of headaches and time. And another thing about these court cases is they're all public. Court cases are in general public unless they have to do with, let's say, children. If a child gets in trouble or if parents are fighting over a child, those proceedings are closed off. But in general, the whole divorce, that's a public matter, just like a probate is a public matter, but they only seal off the records that have to do with people who are younger than 18. So if your case goes through the probate court because you had a will or because you had no will or no plan at all, then anybody that wants to can go into the court and look at your documents and see what you had when you died, how much debt you had, who's getting everything, how much they're getting, and when they're getting it. This allows all of the predators. Now, data mining is becoming a thing more and more and more. This is getting more and more dangerous for people who go through the court system at all, because third parties in other countries that you don't even know and have never heard of can have access to these public documents and see what your children are going to inherit. They can see when they're going to inherit, and they can also target them now for scams or for marriage proposals or for any number of things. So if your stuff is going to go through the probate court, these days, it's worse and worse as far as a privacy issue. And lack of privacy about money invites predators. So one solution for that is create a trust and have a trust control the distribution of your assets after death. A trust can be used as a will substitute. The wonderful thing about trusts is they don't have to go through the probate court. If you put your children in charge of a trust after you die, they take the trust, they take your bank account statements, they take all of your assets, your home, etc., and they sit down at their kitchen table and they do the work that needs to be done. There's no need to file anything with the court. They don't have to publish anything in the paper. They don't have to make any kind of public filing on this. It's all done with the banks and the closing on the home through the title company, but none of it becomes public record. It preserves privacy and it's controlled by you. You can change it during your lifetime, and then it's controlled by your children after your death, and they have to follow your wishes according to who gets everything. That's why people like trust. They've really come on since like the 1970s, 1980s, and now most of the plans that we do these days do not have a will as their basis for after death distribution. They have a trust, usually a revocable living trust. Now, revocable trusts avoid probate, etc., but they are subject to the claims of creditors. So if you owe something on a credit card, or if somebody says you owe them money, they can get it by suing you or your trust or your trustee. With an irrevocable trust, oftentimes the assets are not subject to lawsuits against you. They are not subject to probate as well. Many times these trusts, though, are mainly for the purpose of charitable giving or tax deductions. Most of the irrevocable trusts, that's the ones that are not revocable, they're less common. The irrevocable trusts are usually used for asset protection. And when we use them, we generally use them for protection of assets against spending on nursing care. So that is the key to the irrevocable trust that we do. People take the trust, they create an irrevocable trust, they put their home in there, they put the cabin up north in there, and then they turn over control to the kids. The kids are able to manage those assets during your lifetime. And then upon your death, they just go to the kids. But if you need nursing care, they don't have to sell those assets to pay for your care. They're protected from that. So other people use trusts, and a great way to use trust is for disabled people. If you have a child or a loved one or a beneficiary that's disabled, you should not give them cash outright. That can destroy their ability to claim benefits that are supporting them. So if they have benefits through the SSI system or through Section 8 housing, or if they're on other types of support with social services, and they have a social service advisor, you can wreck that for them if you give them a gift after your death. If they inherit from you, if you give them a bequest, then they will have too much money. Now they don't qualify for those benefits, and they have to spend all the money that you gave them on the things that they were getting from the benefits. And then when they run out of the money that you gave them, they'll have to reapply for the benefits again. So what you want to do, instead of giving them benefits directly, you put it in a special needs trust for them, and now they can have the access to those assets, use it for the things that they want or need, but don't lose their benefits under SSI and other programs. You can also give your non-disabled children assets in trust where they control it, but if they get divorced, they don't lose half of it. If they get sued, they don't lose any of it. If they don't, or if they go bankrupt, they can still save those assets and not have to pay their debts down with them. As long as they have the right kind of trust that you gave them, they can have access to the assets without having the liability of using those assets to pay for debts or divorce. A lot of people like those trusts to give their children. All right, let's talk about estate tax. A lot of people, I've heard about the boogeyman of the death tax. There's a lot of complaints about, well, we get taxed when we earn it, we get taxed when we spend it, and then when we die, we get taxed again. For most people, that's baloney. Don't believe it. If people are trying to get you excited about paying a death tax, unless you have more than $13.61 million, you're not going to have to pay any zero death tax. Okay. Now, for people that have more than that, there are ways to reduce those estate taxes. There are ways to avoid them altogether sometimes. But for most people, in fact, 99+% of the population in Wisconsin, they never have a death tax, and that's not a concern. So I do want to talk about that because the magic number this year is 13.61 million. If a person dies having more than that, and that includes life insurance proceeds, bank accounts, any kind of investments, including IRAs, 401ks, qualified investments, retirement accounts, all of those lumped together, if it's less than 13.61 million, then you don't have any death tax. No worries. Now, in 2026, that ceiling is going to go down to about 7 million. Even so, fewer than 1% are going to have to worry about that at death. But if you're one of those ones, good for you. We should talk too, because avoiding those death taxes is important. But for most people, it's not a concern. What is the concern is, for most people, is the nursing expense at the end of life. Now, people who reach the age of 65 these days have about a 50-50 chance of spending some time in a long-term care facility. Now, 50-50 is pretty high chance, and it's going up every year because people are living longer and longer and becoming, feeble towards the end of life. And for reasons that nobody really knows, Alzheimer's disease is becoming more and more common, so that nursing home and assisted living needs are more common for people these days. So what can you do to save assets from draining away into a nursing home? So I want to back up a little bit, and many people don't realize until they get older that Medicare and your health insurance do not pay for nursing care. They do not pay for assisted living, except under very limited circumstances. Now, they will never pay for what they term long-term care, but they might pay for some nursing care if you go straight from the hospital. You broke your hip, you go from the hospital to the nursing home for rehab. As soon as it stops being rehab, meaning that they will check on you every week. Are you getting better? Are you getting better? Are you getting better? As long as you're progressing towards full recovery, they will keep paying up to 100 days and no more. But as soon as you either stop getting better or 100 days are up, they will not pay anymore. No more Medicare, no more insurance. You're on your own. So that is a scary prospect, because payment of nursing care is about $14,000 a month in the area where I live. It can be less in different places, but it's a scary number, and very few people make that much to pay for that. So what that means is almost anybody that's in a nursing home or in assisted living is probably in a spend down situation. So what we do for people, if they're concerned about the cost of nursing care and they don't have a specialized nursing care policy or long-term care policy, which may cover most or some of the long-term care that they have, then oftentimes they want to set aside assets early so that their children can have those and guarantee that they're going to be able to hold on to those for your security and then their inheritance later on. So we do pre-planning. Pre-planning is when we believe that you've got 5 years before you will ever need to apply for Medicaid to pay for your care. So I forgot to mention that Medicare will not pay for long-term care. Medicaid will. The problem is that Medicaid requires you to have almost nothing before they will start paying. So that's why you have to spend all your money before you can get Medicaid. Another thing is, if you want to get tricky and give everything away to your kids before you apply for Medicaid, well, there's penalties for that. So there's a 5-year look back period. That's why the pre-planning is you should have a 5-year window before it's likely that you're going to need any kind of nursing care. And then you can take assets and put them into the name of an irrevocable trust and save those assets, have them set aside. They can stay there for your security during your lifetime, controlled by your children. And then after death, they pay to your children without having to pay back any of your debts or nursing costs or anything like that. For the other side of this, if people need long-term care now and they haven't done any pre-planning, or they haven't done some set-asides for themselves 5 years before, it's not too late. We can still do crisis planning. We can't save as much when we do a crisis plan, but we can generally save half of everything instead of just watching it all 100% go out the window. So there's pre-planning and crisis planning that we do for our clients. So I want to talk about this Medicaid planning to qualify for Medicaid. Some people have a problem with the whole concept of manipulating your assets, putting them in a certain situation and giving the children control over the assets in order not to have to spend your money on your care. Isn't that somehow unethical? And I'll tell you right now, the answer is definitely not unethical. We all pay into our taxes. We all pay into Social Security. We all pay into Medicare. But for some reason, Medicare drew a line and said we will not pay for certain diseases. So now it becomes discrimination. If you're lucky enough to have cancer, now Medicare is going to pay and you don't have to go broke. Billionaires can have Medicare pay. They still qualify if they're over 65. But if you happen to be unlucky, now I don't want to say that people with cancer are lucky, certainly not. But I use lucky in quotes here because compared cancer to Alzheimer's disease, now it's still a deadly disease. It still wreaks havoc on your body. But in Alzheimer's disease, it also wreaks havoc on your nest egg. All the money and the assets that you've accumulated throughout life for your security and then to give your children something when you're gone, now that's going to be gone too. So that's the unlucky disease. Now, who can choose between cancer or let's say maybe heart disease, which also is treated through Medicare? You don't have to go broke. Other things, other diseases of old age. And who would choose Alzheimer's or Lewy body dementia or Parkinson's? Nobody chooses. So it amounts to discrimination. If you end up with one type of disease, you have to go broke. If you end up with another type of disease, we're happy to pay. That's wrong. So I will help people avoid this discrimination as much as I can with no qualms about it. And if you and your family are facing the prospect of losing everything because you happen to have Alzheimer's disease or they happen to have Alzheimer's disease, we are here to help you. We want to get you in a better place to save assets like everybody else can. So what's the government's plan for if you have Alzheimer's disease and need care? Well, the first part of their plan is called spend down. Now you have to spend all your money on things that benefit you. You can't give it away. You could actually gamble it all away and there's no penalty for that. But usually people spend it on their care. They spend and spend and spend until they have nothing left in the bank but $2,000. All their retirement accounts are gone. Everything is gone except for $2,000. And they can keep their house, and they can keep one car, they can keep a policy of burial insurance, and they can keep their household goods and furnishings. But everything else has to be spent. Now, a lot of people say, hey, that's great. We can keep the house. That's my major asset anyway. As long as I can keep the house and give it to my kids, that's fine. The problem is the second part of the government's plan. Part 2 is called estate recovery, and that is after you die, they take your house to repay Medicaid. Now that whole plan about saving your house is just gone. So once you get on Medicaid, they keep a tab. The government, county, the state keeps a tab. They keep a tab on how much they pay every month for your care, how much they pay for your prescriptions, how much they pay for your inpatient, outpatient care, and your long-term care. And at the end, they present the bill against any property that you kept. Now, they won't go after your kids for it. They won't try to get your kids to pay from their house or their savings, but anything that you kept, they will take. That's the government's plan. You should have a plan that keeps your house for yourself and the kids get it after you're gone. It keeps your business or your farm or other assets for your security during your lifetime, and then that goes to the kids when you're gone. And it keeps your money or a good portion of your money so that it's set aside for your security. If you need nursing care, you should have a nest egg set aside just in case you need something, because the people that have spent everything and now they're on Medicaid, which there's thousands of people like that, they have no security. They have nothing to lean back on. They have nothing to get them the finer things in life. They can't buy a new big screen TV. They can't buy, new headphones or a new set of clothes. They're only allowed $45 a month when you're on Medicaid. So you want to have a plan so that you don't end up like that. So that's it. It's 37 minutes past the hour, and we've gone through a lot of things. I know I've talked a lot and fairly fast. Hopefully it's made some sense to you. And at this point, I would like to see whether we have any questions. Okay, I'll scroll up. Looks like I'll read this out. For wills, the state of Wisconsin has a standard will template on the state website. On this template, it says that the person wants to leave everything to his or her spouse, and if that spouse dies, then it goes to their children in equal parts. If this person is divorced and the ex-spouse is deceased, does that create a complication to leaving the estate to their children? Can the simple will template be successfully used in this case? I am going to have to demur on that. I don't want to give advice about using specific templates. The state of Wisconsin does have a specific will template, and it was created by a committee of the legislature, and then the legislature published it. We actually give people, if people are determined to do it themselves, we actually made that template into a better form. There's 2 templates, and you can download them from our website, I believe, or from our Facebook page. I'm not sure exactly where, but we do not recommend that anybody use them. We do not recommend that anybody use those forms because it's not clear as to what happens in case of this, in case of that. It's just dumb simplified. It does not account for anybody who might become disabled before you pass away, any of your beneficiaries, and you have questions like this, and those cannot be properly dealt with in this form. Your form, the will that you have should say directly outright that everything goes to this person. I mean, in your case, probably you should just start over and just say the kids get everything. If this will was done before you were divorced and then that person died, it's not clear where everything's going to go. So just be careful. Be careful about do-it-yourself stuff. I've been doing this for 25 years. I wouldn't try to build a car myself because I don't know how. I wouldn't try to do surgery on myself because I don't know how. People think that they can do estate planning on their own, and I've seen very experienced attorneys mess this up because their specialty is divorce, but somebody asks them to do a will and they try to do it and they mess it up. And then somebody dies and now the family's got a mess. Imagine if an attorney can't figure it out. People who just download the forms off the web are not going to be able to know what questions to ask, where are the pitfalls, etc. Get a professional to help you with this stuff, because even the state financial power of attorney form is a huge trap, because it doesn't tell you what the problems are. It doesn't say, hey, look out, you need to add these things in here. It doesn't offer that. Just be careful, please. Okay. For the 5-year look-back rule, is there a formula like percentage of fair market value if a property is sold within 5 years of death that triggers the look-back rule? All right, let's see. For example, if you sell the property to a family member, is there a price that is too low that triggers the look-back rule penalty? The answer is yes. A lot of people try to get around the rules. I mean, we know the rules really well, so we have ways to get around the rules, or we use the rules more accurately. We don't get around the rules. We use the rules to our client's favor. The question is, if you sell your property to your child for $100 and it's worth $500,000, obviously that's a gift. Maybe it's not obvious to you, but to the state, it's definitely a gift, and you're going to have a penalty. If you sell it to them for $400,000 and the fair market value is $500,000, that means there's a $100,000 gift, and that includes a penalty. So any amount below the fair market value is considered a gift for the legal purposes in Medicaid. You cannot get around that by saying, oh, I sold the house, I didn't give it away. The fact is, if you gave any portion of that house under fair market value, the state considers that a divestment or a gift, and you have a penalty. All right. Okay. Also, can the look-back rule apply to properties jointly owned and sold with someone who is a sibling? So it's interesting. If you jointly own property and you don't live there, it doesn't really matter. If you jointly own property and your co-owner says they refuse to sell it, then you will be able to get on Medicaid while you still own that property. However, the state will come and put a lien on it up to your half when you die. So your sibling who co-owns the property with you will have to pay off the state at the point that you die if you do it that way. So there's no look-back problem with that, 5-year look-back problem. The problem is the recovery afterwards. So if you co-own property with a sibling, if they survive, they're going to have to deal with a Medicaid lien on that property. All right, why would people not start an irrevocable trust? That is a good question. So there are many reasons why people don't do things. One of the reasons why I've found that people don't do an irrevocable trust is they're afraid to lose control of the property, number one. Number two is they don't have anybody that they trust to manage the property. So those are really the two big things as far as that goes. So let me talk about the first. When you create one of these MAPTs, Medicaid Asset Protection Trust, it's an irrevocable trust. We have many names for it, but I like to call it the MAPT. It saves assets from Medicaid. When you create one of these, as soon as you put the assets in there, they become under control of your children or whoever you trust to manage those. You can't have control anymore. So if the property needs to be sold, it's the child that signs off on that sale. If there's assets like cash in there, the child legally can control the investment, or where that money is stored or invested, etc. Some people do not like to give up that control. What I tell them is I try to get them to think of it not as losing control, but as gaining control. So if you step outside where you think your control is you only, being in control, and you just widen that to your family. Now you've actually gained control. You've got more control if you put your family in the control. Now you personally lose control, but now your family has more control than you ever did, because your family can now decide whether we want to spend this money on your care or not. You never had that decision, so you never had that control. You have to spend that money on your care if it's under your control. But if you spread that out and now you put it under family control, now you have more control actually within your family than you ever did as a single person. So loss of control, many people can't deal with that. And then if you don't have family members like children that you can trust to do the things that you want them to do with the assets that you put in that trust, then you can't really do that. You can't rely on a bank to be the trustee of one of these MAPTs. And the reason that you can't is because the banks will not operate on a wink and a nod. If you tell the bank, hey, look, I've decided I want some of that money back, the bank will not cooperate with you to get the money back, because the trust is very clear that that can't happen. But if your children are in control, there are a back door that they can legally take the money out, give it to themselves or their siblings, and then from there, gift it to you. That's the back door. And family members will do that. Bank trustees will not. Therefore, if you don't have family members, specifically children, grandchildren, sometimes nieces and nephews, if you don't have those people, then don't do one of these trusts, because it won't work for you. Okay? Why would people not start an irrevocable trust? I think it's great in most cases. Also, some people don't have assets that can go into an irrevocable trust. If you have IRAs and that's your main asset that cannot be transferred to an irrevocable trust, it would have to be cashed out, all the taxes paid in that year, and then once it's cash, you can transfer to an irrevocable trust. But as long as it's an IRA or a 401k or a 403b, etc., that asset cannot go into the irrevocable trust, and that's another reason why people wouldn't do it. But a home can be transferred in. You got to be careful about mortgages. If there's a mortgage on the home, you got to be careful that the bank will not call the mortgage due when the property is transferred to the trust. Okay, if not married and own property with significant other, and one dies, will the property go to the survivor? Maybe, maybe not. It all depends on how the property is designated. So if we're talking about real estate, and you own a piece of real estate, and what it says on the deed is John and Mary, not married, then when one dies, their half of that real estate goes to their kids. This person just still owns their half, but they don't get it. Unless it says on the deed, it says John and Mary as joint tenants with rights of survivorship. If that language is on there, it will go automatically to the person who survives. You have to have the right language on the deed or on the account or on the asset in order for it to work, that one party gets from the other party. But you really have to be careful about that. I do not like to have people put property in joint names with the kids in order to make sure that the kids get it, because it's not going to save it from nursing costs. And also, God forbid, that child gets divorced, your house is now going to be pulled into their divorce because they own your house as well. Don't do that as a means of transferring property. It's not a good idea. Unless you're married. The marriage is fine if you co-own property with a married person, but I recommend against it with siblings, children, etc., because their debts are now going to become your problem. Their divorces are going to become your problem. If they go bankrupt, that's also your problem. Or if they just, stop getting along with you, now you've got this problem in between you. I've seen it happen too many times. All right, what's the cost of estate planning? Let's come back to that. Is there a difference between a regular attorney and an estate attorney? Which one is better to work with? Well, I would recommend that if you're doing estate planning, you go to somebody that focuses in this area of law. There are many attorneys that try to do everything, and sometimes they don't do some things very well. Um, I don't want to disparage anybody. There are really great attorneys out there that can do really good work, but I would recommend that you look for somebody that focuses in this area of law. An estate attorney is not really the title of an attorney, but it's somebody that focuses on estate planning, elder law, and estate administration like we do. That's all we do in this firm, so that you know that you're going to have somebody that's familiar with the laws, that's been doing this and only this, and they can tell you what the pluses and minuses and the dangers are. They can point out where things might go wrong. Which one is better to work with? Depends on what you like and what your risk tolerance is. Now, somebody who is specialized in a certain area or who focuses in a certain area is probably going to cost more than somebody that dabbles in that area. So if cost is a major concern of yours, then you might want to shop around. I would tell you, though, that the value that you get or that your children get is going to be greater if you go to somebody that knows what they're doing, because sometimes you'll never know during your lifetime that something was wrong. And your kids will only find out about the mistakes or the problems after you die, and now they've got a problem. So go to somebody who's experienced, that knows what they're doing, and pay a little bit extra in order to get that security that somebody is handling this, that has done it 100, 200, 300 times before. All right. When doing a trust, can more than one person be listed as the power of attorney? So when you're doing a trust, it's called a trustee, but I think I get your drift. Yes, you can have co-trustees. So if you have two different people and you think they can get along and you think that they will both do a good job, yeah, you can put them on there as co-trustees. And then if you have co-trustees, you can say, do they both need to sign everything, or can you let either one go to the bank and do what they need to do? So that's another choice that you have. You can even have 3 or 4 or 5 or 6 trustees. I don't recommend that. 2 trustees is probably good. 3 trustees, I've seen that go very bad because of fights, and there's factionalism, and 2 of them, kind of gang up on the third one. But anyways, yes, you can have multiple trustees. You can have multiple powers of attorney. I really recommend against having more than 2, sometimes 3. But you should have alternates. So if you have a trustee, you should always have at least 1 alternate, and 2 is better. 3 is even better. You can have as many as you want, but after 3 or 4 or 5, probably that's overkill. All right, what is the cost? Okay, we'll get to that. Approximately how much the cost? Okay, great. I love it. People want to get to the bottom line. Hang on, we'll get there. May I ask a follow-up on the joint property question? If the property is sold, can it still be subject to the look-back rule, or is it only if the person is still co-owner at the time of death? So if the property is sold, it depends on when it's sold. If the person is already in Medicaid, because we've exempted that property because the co-owner was not willing to sell. So the person then that, if you're in the nursing home now, you co-own that with a sibling. You've gone through all the rest of your money, and now you're in the nursing home, and then the property sells. Your half of that property has to be given to you, and now you're knocked off of Medicaid until you spend it all. Now, you could just take it and put it in what we call a WISPACT trust. WISPACT is a nonprofit organization that can hold money for elders and disabled people so that they don't lose their benefits. But once it's in that WISPACT trust, the family never gets it, except for, that person can get it for their care during their lifetime. But if they die while there's money in there, it goes to the state to repay Medicaid. So that's if you sell the property after you qualify for Medicaid. If you sell the property within the 5 years of qualifying for Medicaid, now you have accountable asset. That's that cash. If you co-own it with your sibling and this property is sold and they just keep all the money, that's a gift. You've given a gift to that person. And yes, that does trigger a 5-year look back period for the amount that you've given to your sibling by just allowing them to keep the whole amount that they've sold. Okay, let's see. How does a TOD deed compare to an irrevocable trust? Used to be, back in the old days, and it wasn't even all that long ago, it was 10 years ago, you could do a TOD deed and your house, your residence, could be saved from the recovery. No more. They will recover against a TOD. They will recover against a life estate. The state will recover against your home, however you're giving it away, unless it's in one of these irrevocable trusts. If it's in a revocable trust, if it's in a TOD situation, if it's in a joint tenancy situation, any of that, the state will grab onto your portion of that after you die and put a lien on the property. So the TOD does not help with Medicaid protection. Can an irrevocable trust be changed when you are still alive and well? Depends on how you want to change it. Irrevocable used to mean written in stone. It doesn't mean that anymore, but your hands are tied with regard to your ability to change it without the help of everyone else in your family. I don't want to get into that too deeply because we're kind of running out of time. But the answer is it's hard to change an irrevocable trust. The MAPTs that we do allow the person to change who gets it on their death, as long as they choose amongst their descendants or charities. They can change it from equally to your kids to only one grandkid gets everything. As long as they choose amongst the descendants, you can change that part of it. It's hard, though, to remove a trustee that you didn't want in there if they go sour on you. It's possible, but not always easy. A revocable trust, however, can be changed at any time you want. An irrevocable trust, difficult to change. Are there scenarios where you have multiple trusts, a revocable and irrevocable, or is just one master trust with dual components? That's a great question. We always do 2 trusts, a revocable and an irrevocable, when somebody wants to have both of those. We do it often. So you'd have a revocable trust that you're fully in control of, then the irrevocable one where you put the assets that you want to set aside and let the children control. So you have to have at least your checking and savings accounts and enough money in here that you don't have to ask the kids for money a lot, and then just put everything else that you think that you're probably never going to need unless emergency, you put that in the irrevocable. So you do have both. All right, so let's talk about the cost. Cost of these plans depends on your situation, obviously. There are ranges. For us to do an estate plan for somebody, the lower range is going to be about $2,500. Multiple trusts go up over $8,000, sometimes $10,000. We'll talk with you. If you set an appointment, there's no cost to set the appointment, and we'll make a recommendation. Now, generally, the high cost of these trusts is justified by how much tens of thousands, hundreds of thousands that you can save or your family can save, and the peace of mind that it allows you to make sure that your house and your property up north and whatever the hunting land is going to go to your kids. It's just one other thing that you set up to get your ducks in a row. The cost can be a lot. We believe it's worth it in most cases, but if you don't believe it's worth it, then you don't have to purchase after talking to me or to Carly, our other attorney. You're welcome to make that choice at the time. So I would encourage people to move forward. If you've got a little bit of momentum, you're starting to learn about estate planning, take the next step, make an appointment, talk about your specific case. give us some information about you, your family, sit down for an hour, we'll talk, we'll see what the pieces are, and we'll design a plan or recommend a plan for you and quote you a flat fee. If it works for you, then we'll move forward. And at that point, it generally takes about 6 weeks, and then everything is signed and legal. Okay. We are at the top of the hour, and it took the entire hour. Thank you for everybody who came. I really appreciate it. And if you like these things, we have a couple every month. This program, though, is going to be pretty much the same program each time. So if you go into the estate planning program again, that's fine. You can get, a refresher course if you want to, but we also have a program that specifically focuses on Medicaid planning, the planning for nursing care, etc. You might want to view that one, come to it, ask questions, and it's really been a pleasure. Thank you. Have a great rest of your day and a wonderful rest of the summer.